is the technical body with competence over the most important matters related to the administration of arbitral proceedings, appointment of arbitrators and their confirmation, time limits, extensions, determination of cost, and so on. The Arbitral Council is currently composed of 9 members. They are professors of law and practitioners. Currently we have 7 members from Italy and 3 members from abroad. I just want to point out that the members of the Arbitral Council cannot be appointed as arbitrator in the proceeding that we administer, but just it was important to point it out. The Secretariat is the administrative body, and it is composed of case managers, and case managers follow the proceedings from the beginning to the end of the proceedings. They support the Arbitral Council with all the relevant information regarding the process. They also advise and support parties and their councils, and they organize the proceedings, and they also attend the hearings. This is a very important thing, I think, and we really rely on this particular feature of our arbitration system, because they work as secretary of the arbitral tribunal. They take minutes, and being also present at the hearing, they can, supervise the work made by the arbitral tribunal, and this is relevant for the final determination of the cause, and also for for collecting information on how arbitrators perform. Dunque, our rules give parties great liberty in shaping the proceedings according to their needs. So parties can derogate to the rules with some limitation. They cannot derogate those rules which concern independence and impartiality of the arbitrators, time limits, and costs. Those elements, independence, time, and cost, are considered the core principles of our system. So what does it mean in practice? It means that institutions can refuse the administration of cases when arbitration agreements contain provisions which might affect these core. And I just want to mention that our code provides that in case of refusal by the arbitral institution, the arbitration agreement is not null, but the dispute is submitted to ad hoc arbitration. This is in order, to guarantee the parties to have access to arbitration. So as far as now, I want to say a few words about each of these principles. With reference to independence and impartiality, according to our rules, and more precisely according to the Code of Ethics, which is attached to the rules and which is integral part of our rules, arbitrators must be and remain independent and impartial throughout the proceedings. The proceedings is pretty much the same as explained by the Vice President of ICC. When arbitrators are appointed, they have to sign a statement of independence, and they have to disclose any relations with the parties, their counsels, or any other party involved in the proceedings, such as the co-arbitrators. and they have to disclose any interest come of the dispute in the subject matter and any bias as to the subject matter. The statement is forwarded from the Secretariat to the other party, and if the statement is blank and the other party doesn't raise any objection, then the Secretariat will confirm the arbitrator. In case the statement contains any elements or any information, or in case the other party raises objection, then the final decision on confirmation is taken by the arbitral council. As you can see here, we have a high percentage of confirmation, which is good because it means that, you know, parties and their councils are aware of the importance of having independent and impartial arbitrator. As far as time is concerned, as you know, one of the reasons for choosing arbitration is that it is a time-efficient way of resolving dispute. Recently, one of the criticisms brought against arbitration is that is about the duration. Institution, in our view, has to guarantee the party to have a time-efficient administration. And so, in our system, institution wants to have full control on the timing. As you can see here, the average duration of our cases is 12 months and 6 days. But this is the average. So it means that so we also have arbitration cases which goes from 7 to 9 months. That would be a good time for an arbitration. We have two phases. We have a pre-arbitral phase, which goes from the request filed by the claimant to the constitution of the arbitral tribunal, and this phase lasts generally 3 months, and during this period, the Secretariat takes all the necessary measure for an expedited conduction of the proceedings, and then from the constitution of the arbitral tribunal runs the time limit for issuing the arbitral award. Now, this time limit can be extended only by the Secretariat upon request of both parties or by the arbitral council. We do not have automatism, so there must always be a decision on this issue taken by the institution. As far as costs are concerned, cost predictability is regarded, as we have heard here, as a great advantage in international arbitration. In our case, costs are predictable, pursuant to a published fee schedule. The fee schedule is based on the sum in dispute criterion. On the basis of the sum in a dispute, parties know from the beginning how much the arbitration is going to cost. We do not have a registration fee, so the parties the claimant files his request for arbitration, and we forward the request to the other party, who has 30 days to present his defense. And once we have collected these briefs, then the Secretariat determines the value of all the primary claims issued by the parties and request advance payments on the cost of the proceedings. Advance payment is the condition to be met in order to give start to the proceedings. So once parties have paid the advance, we forward the briefs to the arbitral tribunal. Then, during the course of the proceedings, we ask for other payments, along with the activities which has been rendered, and we ask the balance to be paid before the arbitral tribunal issue the award. If a party fails to pay, the other is given the opportunity to make a substitute payment. And if the requested amount remains unpaid, the Secretariat can suspend the proceedings, and if after 30 days from the suspension the parties do not pay, then the proceeding is dismissed. I think do I have time or no? Okay, so I think Daniel has already covered some statistics. I just can add, with reference to the nationality of the parties, I have to say that our parties are mostly from Italy. We don't have many cases involving international parties. As you can see here, I don't know if it's clear, okay, more or less. Under degree of internationality, you can see that arbitration with at least one foreign party were in 2010 24. So it's not that much, but we are working on that. As far as the economic value of the dispute, the average value is 400 and, as you can see, 400 million. So we take all the cases which ICC doesn't want, so we take all of them. I think this could be much of it. Thank you. Thank you very much.
Ms. Morante'ye teşekkür ediyoruz. Kıta Avrupa'sından 3 ayrı ülkeden değişik görüşler dinledikten sonra şimdi Atlantik ötesinde Anglo-Amerikan sistemine gideceğiz. Amerikan Barolar Birliği'nin Alternatif Uyuşmazlık Çözüm Bölümü Başkanı Avukat Sandra Stevens bu konuyla ilgili sunumunu yapacak. Amerikan Barolar Birliği uygulamasıyla ve Amerika'daki genel tahkim uygulamasıyla ilgili mikrofonu kendisine veriyorum. Switch.
Good afternoon. Good afternoon, everyone. Thank you very much for the opportunity to speak with you today, and thank you in particular for those of you who have stayed, since we are getting on late into the day. My presentation this afternoon is intended to provide you with the perspective of how arbitration works in the United States from the perspective of an attorney who regularly represents clients in arbitration proceedings in the U.S., and also based on my role as head of the ADR committee with the American Bar Association. In some ways, as the last speaker on this panel, my presentation is made easier because the earlier speakers, both on this panel and this morning, have provided you with a very good foundation of some of the key aspects of arbitration. But in other ways, my presentation this afternoon is made more difficult in that I have to try harder to provide you with new and interesting information. So I'll do my best in that regard. Sorry, how do I click over?
I don't actually.
Oh, no, okay. Sorry for the technical difficulty. Okay, so these are the topics that I'd like to cover this afternoon. First, I just want to provide you with an overview of some of the alternative dispute resolution initiatives that the American Bar Association currently has. Then I want to provide you with a brief overview of institutional versus ad hoc arbitration in the United States, using the American Arbitration Association as an example of institutional arbitration. Then I'm going to take you through the progression of a typical AAA, American Arbitration Association, arbitration. How do you initiate the arbitration? What happens during and after the arbitration? Then I'll move on to some tips for managing arbitration costs. Costs are an issue that have been covered by some of the prior speakers, so I'd like to add to that discussion somewhat. And finally, I want to provide you with a brief overview of the Federal Arbitration Act, both as it relates to the Convention on Enforcement of Foreign Arbitral Awards that you've heard a little bit about from some of our speakers, and also to discuss a little bit more the scope of review of arbitration awards. The American Bar Association has an alternative dispute resolution committee that explores the practical implications of arbitration, mediation, and negotiation. We currently have more than 700 members, and that number is growing. The committee was formed a number of years ago in recognition of the fact that alternative dispute resolution is a growing field. There's a lot of interest and increased attention from the government, from corporations, from companies, and from their attorneys. And the committee addresses issues that are of interest to participants in the ADR process, and it explores the practical implications of using arbitration. We have monthly conference calls, we conduct continuing legal education programs, we provide periodic teleseminars, webinars, and other educational opportunities for our members. We want to educate them about recent legal developments that impact the ADR community. At the ABA's annual meeting each year, we present a continuing legal education program. We have one this year that will discuss how to negotiate, evaluate, and structure large, complex settlements, focusing on alternative dispute resolution issues such as how to select an arbitrator, a mediator, or a neutral, how to develop a settlement strategy, and how to approach valuation and damages issues. The committee also publishes 2 newsletters each year. We sometimes feature authors, international authors, including authors from academia, foreign attorneys, as well as law students. So if anyone in the audience is interested in submitting an article for consideration in the newsletter, please let me know afterwards. We're always looking for new perspectives. We've heard from earlier speakers today that there are a number of reasons to recommend arbitration over litigation. We've heard about efficiency, expertise, confidentiality, and finality of awards. I want to just briefly address each of these issues. With respect to efficiency, our practice in the U.S. and our goal is to have arbitration awards issued as soon as 30 days after the arbitration ends and after the arbitrators have heard the submission of all evidence. This happens sometimes in practice, not as often as we'd like for it to happen, but in many ways it's still more efficient than litigation. With respect to expertise, the parties can choose an arbitrator who has experience in a particular field. I do a lot of work with insurance companies, so often we're looking for arbitrators who have specialized backgrounds with knowledge of insurance and reinsurance principles. You also have arbitrations involving specific banking issues, construction law, other areas where you may want to have a decision maker with specialized knowledge. With respect to confidentiality, we heard from speakers earlier today that unlike public court records, arbitration decisions are typically confidential. For many businesses, this is viewed as a big positive for arbitration, particularly if a company knows that it may have similar disputes in the future and it wants to minimize the possibility of some negative court decisions on the same issues being used in the future. And then with respect to finality, we've also heard from our speakers today that once an award is issued, at least in the U.S., there's little review available from the courts, so the dispute can be ended more quickly than your average litigation, which must then proceed through an appellate process, which sometimes can be prolonged. With respect to institutional arbitration, we've heard from our earlier speakers today that institutional arbitration takes place before an arbitration association that administers the arbitration based on a set of rules. In the United States, the American Arbitration Association, or AAA, is the main example of an institutional arbitration mechanism. And institutional arbitration is helpful for parties who are not as familiar with the arbitration process. For example, for parties who need help selecting arbitrators, parties who need further guidance with respect to how the arbitration process should proceed. But it can be more costly due to case administration fees. My colleague from Milan mentioned that they do not charge for hearing space. The AAA does charge for hearing space, and the fees can add up, so that is one additional cost you must consider with institutional arbitration. Ad hoc arbitration, of course, is administered by the arbitrators, and it takes place when the parties select arbitrators independently of an association who's going to administer the proceeding. Ad hoc arbitration has the potential to have a lower cost because there are no case administration fees. Ad hoc arbitration tends to be better for parties who are familiar with the arbitration process, for example, who arbitrate regularly and have a specific pool of arbitrators that they regularly call upon for resolution of their disputes. This is something, again, that I see a bit in my practice in the insurance field. It tends to be a very specialized area with a number of arbitrators who are used over and over again by parties in the disputes. So ad hoc arbitration is better in this regard. Aside from the administration aspect, ad hoc arbitration in process is pretty much similar to institutional arbitration. And when we're talking about institutional arbitration providers in the U.S., of course, we've got the American Arbitration Association and the International Center for Dispute Resolution. The AAA addresses U.S. and international disputes. It administers cases where the contract that the parties have specifically designates the American Arbitration Association, or if the parties do not have a contract that says that they want to have the administration done by the AAA, they can actually write to the AAA by consent and agree to submit the case to the AAA. Just to give you some statistics, you can see from this slide that in 2010, more than 143,000 cases were filed with the American Arbitration Association. Speaking briefly about ICDR, I'm planning to focus more on U.S. arbitration and therefore more the AAA, but ICDR is the international division of the AAA. They have a worldwide arbitrator and mediator panel, and in 2010, more than 800 cases were filed with the ICDR. This slide here provides you with some statistics from a report provided by the American Arbitration Association a few years ago. I believe the most current numbers are from 2008, 2009. But you can see here that Averages are based on claims that are valued between $75,000 US and $500,000 US. And you can see here that from the filing of the arbitration on day one, usually an award after it's progressed through the arbitration and you actually have the award can take on average of about 297 days. For claims that are valued between $1 million and $9.9 million, on average, the award time increases to about 414 days to the award. The least time you can get an award with a claim at that value tends to be around 300 days, the most 563 days. And then this then again increases if you have claims valued above 10 million US dollars. On average, they're going to take about 474 days to reach the award from the initiation of the arbitration. And they can take up to as much as almost 600 days. Some of our speakers on the panel took you through the progress of a typical arbitration based on the particular institutional arbitration mechanism that was being used. I want to take you briefly through the progression of a typical arbitration under the American arbitration rules, beginning with the selection of whether you're actually going to use the AAA or an institutional arbitration provider, or whether you're going to do an ad hoc arbitration independent of any institution. Then I'll take you through the arbitration demand, the selection of arbitrators, the preliminary hearing, discovery, the evidentiary hearing, and then the arbitration award. So again, the first determination is whether you're going to have an institutional or an ad hoc arbitration. One of the first things that I recommend to my clients is to confirm in the first place whether they have an arbitration clause in their contract. If that arbitration clause applies to the dispute, does that arbitration clause then specify that the AAA is supposed to be used for the proceeding? If the AAA is designated, the parties will most likely proceed to institute proceedings with the American Arbitration Association. Sometimes, if the parties have a general arbitration clause in their contract that does not specify how the arbitration should proceed or how it should be administered, as I mentioned before, they can then agree to consent to have the AAA administer the arbitration. With the American Arbitration Association, you're going to initiate your case basically with the filing of the arbitration demand. And the purpose of the arbitration demand is to provide a statement of the claims and the damages that you're seeking as the moving party. Typically, when you submit the arbitration demand, you also have to provide the AAA with a copy of the contract that contains the arbitration clause so that the AAA can be satisfied that they actually do have the ability to administer the case. And of course, you have to pay the AAA filing fee, which can vary depending on the case value. Once the arbitration has been initiated and after the opposing party has filed an answer to the arbitration demand, the arbitration selection process for the arbitrators can begin. As I mentioned before, sometimes you may want an arbitrator who has specific qualifications in an industry, franchise, construction, insurance, and if that is the case, you can advise the AAA that these are the specific qualifications that the arbitrators that you are going to select must have. And then once you advise the AAA that industry expertise is necessary, the AAA can look to its national list of more than 8,000 arbitrators and provide you with a set of names and biographies of the candidates who meet your specific qualifications. Of course, the AAA encourages the parties to try to agree on an arbitrator, if it's going to be a sole arbitrator or if it's going to be a panel of 3 arbitrators. Typically, one side will choose a candidate for each of their sides, and then an umpire or a chair can then be mutually agreed upon by the parties. If the parties are unable to agree on the arbitrator or arbitrators, typically the AAA will have the parties rank 1, 2, 3 in their order of preference, the candidates for the position, and then the AAA can appoint a candidate based on that ranking. There is an opportunity to object to the arbitrator who is appointed. We heard some of the speakers this morning and afternoon talk about the importance of an arbitrator being disinterested and being objective. If a party has concerns about a particular candidate who has been appointed by the AAA, you typically have the opportunity to challenge that appointment, and then that process will work itself out until a mutually agreeable candidate is arrived at. The next step in the arbitration process is the preliminary hearing. And at the preliminary hearing, the parties basically explain what their claims and damages are if they're the moving party, and of course any defenses that they have or counterclaims if they're on the responding side. And this is the first time that you have the chance to present your case to the arbitrator. So even though it's a preliminary hearing and no evidence is presented, you are making a statement of your claims and defenses, so it's an important stepping stone in the arbitration process. Many times, this hearing will be conducted by conference call so that costs can be minimized and the parties do not have to travel for the preliminary hearing. Other issues that are discussed during the preliminary hearing include how much discovery or information exchange there's going to be, how many witnesses there will be. Sometimes you'll discuss with the arbitrators what the general scope of testimony from those witnesses may be, and also address the question of whether you will have any expert witnesses. The parties can also discuss with the arbitrators how long the hearings are going to be, where they're going to take place if there's no specific provision in the contract for a hearing location, and also discuss any other relevant deadlines that the arbitrators should set for the arbitration. When the discovery or information exchange process begins can depend on how quickly you want your case to move along, because parties can begin exchanging key documents and information in support of and in defense of their claims as soon as the arbitration is initiated. If they can't agree on how much discovery they're going to have or cannot agree on what form the discovery will have, then of course the arbitrators can set appropriate requirements or limitations on the discovery. Typically, it's recognized in the U.S. that the scope of discovery and information exchange is much more limited in arbitration, and the purpose behind that is to allow arbitration to move forward more efficiently than litigation, because typically in litigation, if you have document requests, depositions, written interrogatories, and all these other devices for discovery and information exchange, it's going to take longer before you can get to the point where you're actually arguing your case. Therefore, in arbitration, the arbitrators will usually allow you to exchange information in the form of document requests. However, they're going to place limitations on depositions and written questions. As you can see from this slide, typically depositions and written questions are only upon good cause shown, and they have to be consistent with the expedited, faster nature of arbitration. After discovery, the parties may move on to the evidentiary hearing stage. I say may because what we're seeing in arbitration these days is sometimes parties are trying to do briefing before the hearing stage in an effort to try to streamline the issues that are actually going to be resolved at the evidentiary hearing. So sometimes you may have briefing before you move to the evidentiary hearing phase. Other times the parties want to move into the evidentiary hearing phase straight from discovery. We heard from some of our speakers today that the evidentiary rules are much more relaxed in arbitration proceedings, and this is very much the case with the American Arbitration Association. As you can see from this slide, one of the AAA rules provides that conformity to legal rules of evidence shall not be necessary. And in fact, in many arbitrations, we have arbitrators who are not lawyers. They are professionals in particular industries, whether it's, again, franchise or insurance or banking. These are people who may be experts in their field, but they're not necessarily lawyers. Therefore, we often see that arbitrators don't look to the rules of law in rendering their decision, and instead they'll rely on industry custom and practice, and they'll look at equitable considerations as well. Basically, they do not need to apply strict principles of law. And in addition to the AAA rules, we see in a lot of our contracts in the arbitration clauses themselves, parties have written in something to the effect of the arbitrators may consider industry custom and practice and do not need to adhere to the law. Of course, this can cut both ways. If your party has a very strong legal argument, you may feel that you're disadvantaged if the arbitrators are going to look more to custom and industry than to the law. On the other hand, if you think you have a better business side argument, you may be very happy with the fact that the arbitrators are going to look more at equitable principles instead of strict interpretation of the law.
Law means substantive law or procedural law?
Either. They do not need to look to procedural law, and in fact, many of the evidentiary objections that you see in court, arbitrators don't want to entertain them at all. And with respect to substantive law, no, they're not bound by that either. And again, it makes sense because many of our arbitrators are not attorneys. We do have many who are, but there's a large number who aren't. After the hearing, after the sides present their evidence, whether it's through witnesses on the stand or sometimes through written submissions, the arbitrators will then decide whether there are any issues as to which they still have questions, and they may request post-hearing submissions. Some arbitrators may request post-hearing briefs after the hearing to summarize all the evidence because they want everything laid out for them in a very linear fashion. Other arbitrators will decide that if there are 3 issues, for example, 2 were fully addressed during the hearing, no further information is needed about them. In that situation, in that example, they will then ask the parties to brief just a single specific issue as to which they still have questions. You've heard from some of our speakers, again, I feel like I'm saying that phrase a lot, but they did provide a very good basis of the topics that I'm covering. Some of our earlier speakers did mention that depending on the jurisdiction, the arbitrator doesn't have to provide you with an explanation of the award. In the U.S., this is certainly the case. As you can see from this slide, the AAA has a specific rule that says that the arbitrator does not need to issue a reasoned award unless the parties request such an award in writing. And if they want a reasoned award, they have to make that request before the evidence is presented. They can't decide halfway through the hearing that they'd like an explanation of the award. They have to make up their minds early on that they want an explanation in writing. What happens if modifications need to be made to the award? The AAA, again, has a specific rule for this with respect to changes, and the parties can ask the arbitrators to correct obvious mistakes, such as typing, spelling, or math errors. We heard from speakers about the fact that there are computational errors frequently, and this is an issue that the AAA deals with as well. And if the party is going to request that the award be modified, it has to do that within 20 days after the award is issued. And as you can see from the slide, if you're reading along, the arbitrator cannot take another look at any of the substantive issues that were decided. The only purpose here is to correct any obvious mistakes. They can't, look at the main issues again. So hopefully that provides you with a short overview of how an arbitration progresses at the American Arbitration Association. I'd like to talk now about some tips for managing arbitration costs. Some of these are something that should come naturally to most of us to focus on key issues, but sometimes when you're in an arbitration and you're the party who wants to make sure that you're getting as much information for your case as you possibly need, sometimes there's a tendency to look more broadly at the issues, and therefore if you try to just focus on the key ones, that's one way to make the arbitration costs lower. And if you specify in your claims and defenses and specifically focus on those issues, it makes discovery and resolution simpler. I also talked about the fact that sometimes you might have one arbitrator, sometimes you might have a panel of three. Certainly consider using one arbitrator instead of three, because if you have one arbitrator, you're clearly paying a smaller percentage of the costs. We see situations where our clients have provisions in their contracts in the arbitration clause that specify 3 arbitrators, but the parties will then tell their lawyers, why don't you go and ask the attorney on the other side if they'd be willing to agree in writing that instead of having a panel of 3 arbitrators, we'll do this with 1 arbitrator. And I have had a number of situations where we've done that because either my client or the client on the other side has asked their attorney to reach out and say, let's try to keep costs down, let's have 1 arbitrator instead of 3. And certainly, if you're working with opposing counsel on a proposed scheduling order and trying to work through as many issues as you can so that there's less for the arbitrators to have to address during the hearings, that will also help you to minimize costs. I also have on here streamlined discovery. You really need to consider how much information is needed to support your claims or defenses. Do you really have to ask those 10 questions, or will you really get to the main issues if you just ask 5? And then consider using pre-hearing briefs to streamline the issues for hearing. Are there any legal or custom and practice arguments that you can set out on paper and get that in front of the arbitrators before the hearing? Can you get some perhaps partial ruling from them on some issues before you go to hearing on the rest of the case? And then from a logistics standpoint, you can certainly consider alternatives for hearing presentation. I've had arbitration hearings where instead of paying the costs of having the witnesses to fly to New York or Los Angeles or wherever the arbitration is, we've actually done live video testimony, or we've even obtained authorization from the arbitrators to play back pre-recorded depositions so that we can minimize costs in that way. I had mentioned the fact that in specific industries such as insurance, you might have a specific pool of arbitrators that you go to on a regular basis in ad hoc arbitration. And on this slide, I just provided 2 examples of language that has been quoted in court decisions, and this language is taken from actual arbitration contracts in the insurance world, where there are specific requirements such as, the arbitrators being executive officers of insurance or reinsurance companies, or that they, in the second example, that they have knowledge in the specific matters that are being addressed. So again, parties can write into the arbitration clause specific requirements for their arbitrators. This slide here, I just want to briefly mention, there's an organization in the U.S. called Arias US, and it stands for the Arbitration Reinsurance Insurance Association Society of U.S., and basically they're an arbitration facilitator with the goal of improving the arbitration process by training and certifying arbitrators, and they specifically focus on insurance and reinsurance issues. And as arbitration is being used more often in the U.S., we're seeing other organizations like this, based on specific industries, grow and develop in an effort to assist arbitrators. The one interesting comment about Arias is that they were formed partially in recognition of the fact that many insurance arbitrations were being conducted by executives or former executives of insurance companies who were not attorneys and did not have a background in how an arbitration should be administered. So it was in some ways a response to provide parties with an alternative to the American Arbitration Association administered process. let me talk now briefly about the Federal Arbitration Act, or the FAA. Generally, it's divided into 3 chapters, and don't worry, I'm not going to take you line by line or paragraph by paragraph. I just want to highlight a few things. Chapter 1 generally deals with the general provisions, and the purpose behind the Federal Arbitration Act is to embody the strong federal policy in favor of enforcing arbitration agreements in the U.S. and to make sure that written agreements to arbitrate are generally valid and enforceable. So we have these provisions here, with Chapter 1 being the general provisions, and Chapter 2 deals specifically with the Convention on Recognition and Enforcement of Foreign Arbitral Awards. We've heard from other speakers that Turkey is a signatory to the convention, so this chapter of the FAA would apply in any dispute, for example, with a Turkish company and a U.S. company. And Chapter 2 incorporates some of the general provisions in Chapter 1 with respect to how the arbitration should progress, and I'll talk about those in a moment. Chapter 3 I'm not going to focus on here because it's the Inter-American Convention on International Commercial Arbitration, and basically deals more with disputes with Latin American countries. So, as I mentioned, the Federal Arbitration Act has a number of general provisions. Section 3 is a very often relied upon provision because it allows the parties to ask the court to put the court litigation on hold while the arbitration proceeds. So let's say, for example, that you have a contract with an arbitration provision and you have a dispute with your opponent. Your opponent does not want to arbitrate. They bring suit against you in court. You can then ask the court to put that litigation on hold based on the fact that your contract has an arbitration provision. And if the court finds that the arbitration provision is valid and it applies to the dispute, it will then stay the litigation, and it's not an option for the court. The court has to put that litigation on hold while the arbitration proceeds. Some courts in the U.S. have taken this a step further, and they've actually dismissed the litigation in favor of the arbitration so that the purpose of the contract and the intent of the parties can be carried out. Yes, and since I need to wrap up, I'm just going to go very quickly here. There are some other general sections of the Federal Arbitration Act, and these are similar to what I've discussed with the American Arbitration Association rules. There are provisions for arbitrator appointment, provisions for information exchange and discovery, provisions on how an award can be confirmed at the conclusion of an arbitration, and then there are specific statutory grounds on which an award can be overturned. And as you can see, there are very limited grounds, as you've heard from my colleague from the U.S. this morning. You have to show corruption or fraud. You have to show that the arbitrator was biased or acted in some other inappropriate way, or that the award went beyond what the arbitrator or arbitrators were empowered to do by the contract. Similar to the AAA rules, there's also grounds under the federal rule to modify or correct an award if there's some error in calculation or form. And in some, let me just leave you with this slide, which has some helpful ADR resources, websites, American Bar Association, the American Arbitration Association, and Arias. And I know that we're going to be taking questions from all of the panelists, but if you have any questions that are not answered today, or you think of something in another day or so, this is my email information. Please feel free to contact me. Thank you.
Çok teşekkür ediyoruz. Çok teşekkür. Evet, bunda da zaman kaybetmeyelim. Geç başladık, geç devam ediyoruz. Çok kısa bir süre sorularınızı alıp kısa bir ara vereceğiz. Daha sonra buradaki konuşmacı